Welcome, everybody. We're just going to give everybody a moment to join us. We're going to get started in just a moment. Thanks for joining us today. We're looking forward to this webinar. We'll give you all a moment to join us and we will get started. If you have any questions during the session, you can use either the chat function or the Q&A box at the bottom of your screen, and we will ask our panelists during the webinar so that they can answer your questions as we go along. All right, let's get started. Hello and welcome everyone to the ILN's AI and Intellectual Property, Copyright, Trademark, and Patent Perspectives from Germany and the US. We are really happy to have you with us this afternoon and this morning, depending on which time zone you're joining us from. We have 4 wonderful panelists from our 2 firms here today to talk to you. I'm going to let them introduce themselves to you and get started with our panel. Just a few brief housekeeping notes for you today. That's a great question. Does the seminar have CLE for Ohio? We are not doing CLA for the seminar, but I believe if you want to apply for CLE directly yourself, you can do that and then reach out to me afterwards. I will give you my email address so that you can reach out to me afterwards and I will approve your hours. So if you want to ask questions in that Q&A box at the bottom or in the chat throughout the session, I will ask them of our panelists as we go through the session today. So with that, I will turn it over to Vanessa and Marissa, who are going to kick us off for this session. Vanessa and Marissa?
Perfect. Thank you, Lindsay. Good morning or good afternoon, everyone. My name is Vanessa Pantelakis, and I'm a partner at Wolpert Rechtsanwälte. We are a boutique law firm situated near Frankfurt, and we are specialized in IP, competition law, and contract law. I also brought my colleague Marisa with me. So Marisa, please proceed.
Hello, thank you, Vanessa. Yeah, I'm Marisa Roshi, and I'm an associate at Wolpert Rechtsanwälte. Thank you.
So I am Aaron Fishman, and I am a member here at McDonald Hopkins LLC in Cleveland, Ohio, in the U.S. And we are a boutique group within a general practice law firm. And Andrew and I have many years of experience operating in the IP space exclusively. We handle patent, trademark, copyright, and related areas of intellectual property. Andrew?
Yeah, so as Aaron said, my name is Andrew Jenkins. I'm also a member at McDonald Hopkins. Similar to Aaron, my background is primarily in patents and trademarks, and even more specifically in electrical, computer, and AI technologies.
Perfect, thank you. So I will start with our presentation. I will let everybody see the presentation in a second. So Marisa and I will today tell you something about AI and copyright and trademark law in Germany. Before we started the presentation, I asked ChatGPT to create an image for this webinar. Anyhow, ChatGPT missed out to include the trademark aspect, so you always have to check the output twice whether it fulfills your interests. We have brought you a short agenda. The first topic is training AI on copyrighted and trademark protected material legally permitted. The second point is who owns the rights to AI-generated content. The third topic is there a labeling requirement? The fourth is, can AI-generated content infringe copyright and trademark law? And the last point is, how does or will the EU AI Act impact the use of AI within the European Union? We will now start with, I would say, the biggest point of this presentation. And we take a look as whether the training of AI can infringe German copyright. Copyright protects original works of authorship, such as literature, music, and visual arts. In Germany, copyright is governed by the Urheberrechtsgesetz and grants authors the exclusive right to reproduce, distribute, and modify their works. Otherwise, as in the US, you cannot sell the copyright. It always stays with the author in Germany. The problem is that AI systems are trained, amongst others, with copyright-protected works. Therefore, the training with those works could constitute an infringement of the author's exclusive right to reproduce his work. Unlike the US, Germany does not recognize the concept of fair use of copyrighted works. Instead, we have some exceptions of the author's exclusive right, such as temporary acts of reproduction, text and data mining, and text and data mining for purposes of scientific research. Therefore, you will always have to check whether one of these exceptions is applicable when training AI with copyright-protected work. We had recently in Germany the first decision if the training of AI with copyright-protected work is permitted. The regional court in Hamburg decided that the training of AI in this case was permitted due to the grounds of text and data mining for the purposes of scientific research. The court also stated that in general, AI training with copyrighted work can also be allowed for the reasons of text and data mining itself. But in this case, this was not applicable. I will tell you why. The case was based on a lawsuit filed by a photographer against a non-profit organization named Lion. The association had set itself the goal of promoting research in the field of artificial intelligence by providing open data sets to train AI. So they had a lot of sets where you can train your AI on. One of the images of the data set came from the photographer, and Lion got this photo from a website named Big Stock, and the photographer had uploaded his work there. In Big Stock's terms and conditions, there was the exception that the photo may not be used for automated programs. This will be important later. So the court had to check whether Lion's use of the photo in that data set was legally okay or if it was illegal. First of all, the court pointed out that that data set was not a temporary act of reproduction because the displaying of the photo was not only temporary. Then the court take a look at the exception of text and data mining. The court decided that the exception of text and data mining could be applicable here. Anyhow, the problem with this exception is that you can opt out of the use of the work when it comes to text and data mining. You can opt out if you have that exception somewhere nearby your photo in a machine-readable form, which means in that way, in this case, Big Stock had the terms and conditions, and it was noted there that the use of the photo is not allowed for that automated programs. Therefore, the exception of text and data mining did not apply in this case. Anyhow, the court ruled that the use was permitted according to the exception of text and data mining for the purposes of scientific research. An opt-out is not possible when it comes to text and data mining for the purposes of scientific research. Anyhow, with regard to this exception, it's always important that the data mining does not pursue any commercial purpose. According to the regional court in Hamburg, this was not the case with Lion. Therefore, the lawsuit of the photographer was dismissed. Anyhow, and this is a disclaimer, this was just a first instance decision. And this decision is at the moment already appealed. So we will have to take a look and check whether the decision will be upheld or if it will be dismissed, or if another court in Germany maybe decides otherwise, which is also possible. I know this was a little bit long and extensive. Anyhow, it will be shorter with regard to the trademarks. And the question if the training of AI with trademarks is permitted. A trademark infringement is only given if there is a trademark-like use of the trademark. Therefore, the use of trademarks or logos as training data does not constitute a trademark use, as the AI training software does not use the trademark as a trademark, to name products or services. So we are coming to the question who the owner of AI generated content is. In Germany, it cannot be the AI itself, as copyrighted works need to be personal, individual creations. Therefore, the output of AI is not protected by copyright in general, which in a next step means that third parties can use the AI created content as well, as it is not protected by copyright. Anyhow, there is the possibility that you can modify the AI output in a reasonable way so that you have changed the AI output to something creative yourself. So if you create that necessary level of creativity for copyright protection of an AI output, it is possible that you may receive copyright protection for that edited work, not for the work before, but for the edited one. And then we come to the point that you can, of course, apply for trademarks for the names and logos that are created by AI. We have then also take a look at the question whether there is a labeling requirement for AI generated content. And in general, in Germany, there is no labeling requirement at the moment. Anyhow, in the EU AI Act, where Marissa will tell you something about later on, we have a regulation which sets a labeling requirement for deepfakes as of August 2nd, 2026. So in more than 1 year. So if you then use a deepfake in the internet, you will have to label it as a deepfake or as AI created deepfake. Despite that, as far as I know, social networks already require AI generated contents to be labeled. We will now take a look at the question whether AI generated content can infringe copyright or trademark law. First of all, we have ChatGPT, or we have asked ChatGPT if their services can infringe copyright or trademark law. And this was the answer we just got directly from ChatGPT. No, my services are designed to respect copyright and trademark laws. I generate original content and ensure that trademarks, logos, and creative works do not directly copy or infringe upon existing intellectual property. We will check that information a little bit later in that presentation. We will first take a look at if AI created content can infringe copyright. As we already have discussed about, AI is trained on copyrighted works. So therefore, there is the risk that the output of the AI is based on copyright protected works. Therefore, there's also a high risk that AI-generated works resemble existing copyrighted works, so you will have an outcome that may constitute a copyright infringement. Therefore, if you use ChatGPT to create photos, you should always check whether the output may infringe copyright of third parties. The same applies to trademarks, as AI-generated trademarks may also be influenced by existing earlier trademarks, which may lead to a trademark infringement if the trademarks are confusingly similar. Therefore, a legal check is recommended before using AI-generated trademarks as well. And as I've already told you, we have tried to generate some new trademarks with the ChatGPT to check whether that may constitute a trademark infringement. So in this case, we have asked ChatGPT to create a trademark for mobile phones containing of an apple. As you can see, the outcome is a really nice apple, which may lead to the and that Apple will take actions against our smartphone with that nice Apple. So you have a clear trademark infringement. However, we have just provoked this infringement in this case, as you can see. So we have also asked ChatGPT for a creation without any specification. So we have asked ChatGPT to create a trademark for mobile phones, and we got the name Nexora out of it together with a logo you can use on the back of the smartphone. I think the name is quite nice, and I did not recognize this name before in connection to smartphones. Anyhow, we did a trademark check online, and we found the following trademark named Nexora, protected in Benelux for, amongst others, mobile phones, smartphones, and so on. The trademark was applied for at the beginning of 2025, which means it's also still in the grace period, and the user can take actions without proving that he uses the trademark already for smartphones. So in this case, we also, or again, have an infringement of existing trademark law with the creation of the AI. Therefore, we always have to check carefully the output of AI, whether it's legally permitted or not. And now I hand over to Marisa to tell you something about the EU AI Act. Marisa, please proceed.
Thank you, Vanessa, and hello everyone from my side again.
Excuse me, sorry, Marissa, to interrupt you, but there is a question for Vanessa. Heineck asks, he was under the impression that the defendant in the proceedings before the Hamburg court was a nonprofit organization, but it provided data sets for the commercial use. So how did the court address the fact that this practice, using the pretext of exception for scientific purposes, could circumvent the general principle of opt-out from data mining?
Well, the court said that Lion, who was the nonprofit organization, had no commercial gain. Therefore, the court did not decide whether later on there may be a commercial purpose with the training of the AI. So the court relied the decision only on the case that Lion did that for nonprofit, not the later use of the data set. I hope this is sufficient. Otherwise, please interrupt me.
Thanks, Vanessa. Sorry, Marissa.
You're welcome.
All right, then hello again from my side. Vanessa already mentioned the European Union Artificial Intelligence Act, or short, the AI Act, in regard to the upcoming labeling requirement for deepfakes. Now, the AI Act is a very complex set of rules that I could spend hours talking about. But don't worry, I won't. Nevertheless, as it will affect many companies, we cannot justify not giving you at least a brief overview of the regulations the AI Act provides and what they will mean for companies in particular. While the first parts of the AI Act have already been enforced since February of this year, the other parts will now gradually come into force. The AI Act applies to individuals and companies based in the European Union or offering services on the European market. This means that it applies not only to suppliers, importers, distributors, and manufacturers of AI systems, but also to users. Furthermore, it also applies to providers and operators of AI systems in third countries, even if only the results generated are used in the European Union. As you can see, this is a very broad area of application, and many companies will have to comply with the AI Act in the future. For this reason, we have outlined the most important regulations for each risk group category in this slide. As you can see, the AI Act distinguishes between 4 different risk groups to which different regulations apply. Now, let's start at the bottom. First, there are the low-risk AI systems, such as video games or translation software, for which there are no regulations at all. Then we have limited risk AI systems, such as chatbots, where there is an interaction with individuals and for which there are transparency obligations. These include, for example, training for employees or the disclosure of transparency reports. Next, there are high-risk AI systems, such as credit scorings, medical AI, or application AI, where there is potentially a high risk of damage. For those AI systems, strict requirements apply, like, for example, risk assessments and the declaration of conformity. And then, on top of the list, we have the bad guys, the completely forbidden, unacceptable risk AI systems. Those are the ones that violate fundamental personal rights, like, for example, social scoring and manipulative AI. As violations of the AI Act can be punished with heavy fines, we strongly advise companies to review their use of AI and take compliance measures. There is no case law on the AI Act yet, so it remains to be seen how exactly the rules will be implemented and applied in practice. So let's wait and see. Until then, if there are no questions, thank you for listening. And then we would pass on to Aaron and Andrew for the UF perspective.
Thank you both. So I think, again, I'm Aaron Fishman, and I think Andrew is going to put the slides for us up on the screen here.
Was visible to everyone?
Yeah, can you put it into slide mode
Was
from the beginning?
yeah.
Upper left. So,
Is that better? Or
yeah, I'm just seeing your
ah,
window, but that's okay. We'll work off of that. So, as we heard from Vanessa and Marissa already, we're going to talk a little bit about AI, but we're going to approach a couple of different topics from the US perspective, but most of this is, as it is evolving, seems to be pretty consistent across the world. And we're going to look at the issues relating to patenting AI and what AI means to inventing. Get the next slide here, Andrew. We're still looking at the very first slide.
oh.
Maybe I can share mine, and then you can switch back over to yours. Not sure if I have the permission to do that.
If I may interrupt, if you start the presentation, Andrew,
Yes.
and the full screen mode, you have to share the full screen mode
Right,
too.
right.
So this is how it worked with me. So maybe this is helpful for you.
There we go. That's
it. I think we're in business. We needed an AI that we could ask the question.
There we go.
Vanessa did a much better job.
My apologies.
So we're technology people. We deal with patents, but today we had a little technical issue. But going back to what Vanessa talked about a lot about ChatGPT, and I would say just a few short years ago, none of us had heard of ChatGPT. In fact, it only became public in the end of 2022. But already here we are at the beginning of 2025, and I think that all of these AI tools have become very ubiquitous. It's almost hard to go about your day without interacting in some way with an AI of some sort. And for people doing their jobs, this is also true. AI is everywhere, including at our places of work. And truth be told, I think it can help us do our jobs better. But if your job involves creating new things, new ideas, this sometimes results in AI helping you invent things. As IP attorneys, of course, we think of patents. Businesses think of patents for protecting things that we invent, and they truly can be very useful and transformative for a business. But in order to use them to our advantage, we need them to be valid, enforceable patents. And in the US, as in many other countries, naming who the inventor is important to ensure that you can obtain a patent and enforce your patent and maintain your patent's validity. When we start to use AI, as I'm sure many of us are already doing, then the question is, who is the inventor? What if the AI is doing inventing? For me, this is a very interesting question, as I've spent my career dealing with patenting, and really not something we ever had to think about before. Under the current US law, as a result of a recent case, not too recent, but within the last couple of years, and as really consistently throughout the world, courts have been deciding that an artificial intelligence entity cannot be named as an inventor. It must be a human. And in fact, this case in the US has been kind of happening all over the world. Dr. Stephen Thaler, a few years ago, developed his own AI that he thought would be helpful for him. And actually, he has a history of doing this. He created an AI system that he wanted to create inventions for him rather than doing the work. He filed 2 applications in the US, as well as in many patent offices around the world, naming the AI, which was called Davis, as the inventor. The US Patent and Trademark Office, along with most other patent authorities around the world, refused the applications for lacking a valid inventor. He appealed this decision of the Patent Office to the Federal Circuit Court of Appeals in the US and to many other authorities around the world. The US court, as well as many of these other courts, has decided that an AI cannot be an inventor. A human must be named as an inventor. So for the time being, after Thaler, you must have a human being named as the inventor, or you cannot get a patent. So then the natural question is, when you develop an invention using AI, how do we know who the inventor is? How do we know if a human can be named as an inventor? So in response to Thaler and to, I think, the growing body of patent applications in the US, the Patent and Trademark Office issued a set of guidance documents for how to consider the issue of invention and who is the inventor when AI is involved. Can we go back one slide, Andrew?
All right.
So because the US courts haven't definitively approached this question, they merely said that a human must be named in Thaler, and there have been some other lower court cases that have considered issues surrounding this. We don't have a clear answer yet, but the Patent Office decided it needed some guidance both for its examiners and for prospective patent applicants to decide who an inventor was. So now getting into briefly what the guidance was. So what the Patent Office looked at is an existing set of laws that came out of a 1998 court case in the US, Anu versus iLab Corp. And the court came up with some factors to consider in determining whether someone is an inventor and or can be named as a co-inventor based on their contribution to the process of inventing. These are known in the US as the Anu factors, and we have been using these for nearly 30 years now to determine whether an inventor should be named. And these factors quickly really boiled down to the kind of contribution a person makes to an invention, whether it's significant, whether compared to the full invention, their portion is significant quality, and it really whether they've done more than just identifying existing concepts, current state of the art, and saying we need to invent something that will address this issue or question. So it really comes down to how much of a contribution you make and what kind of contribution that is. And so the Patent Office has, we can go to the next slide, Andrew, has decided to apply those factors logically to determining whether a human contributed enough to an invention to be named as an inventor, which seems most appropriate, but I guess the courts will decide in the coming years if this is the correct approach. So when they considered these factors in Anu, they essentially developed 5 guiding principles for how Anu should apply to a decision about whether to name a human being as an inventor in a invention where AI was involved in its creation. So very quickly, these 5 factors. The first one I think is maybe one of the most important, and that is they have concluded that the mere fact that you use an AI system to come up with an invention doesn't mean that a human isn't an inventor, and it doesn't mean you can't get a patent. However, simply recognizing that a problem must be solved or having an idea for what you want an invention to accomplish and communicating that to someone or to an AI isn't enough. That's not enough of a contribution. So you can't merely say to ChatGPT, invent a way of delivering a presentation about AI on the internet and take credit as an inventor of today's presentation. Reducing an invention to practice, meaning making the invention, is also not enough under factor 3. You had to have been contributed in a more significant way to its development. The person who develops an essential part of a claimed invention doesn't have to participate in every step that led to the invention to be named as an inventor, so long as their contribution was significant in what is ultimately being claimed as the invention. And then I think that maybe the second most important, beyond the first point, is while you can patent something where an AI was involved, simply being the owner or the one that controls the AI and instructing the AI what to do does not make you an inventor. So really all of this comes down to AI inventions can be patentable, but you have to do something more as a human being to contribute to the invention than aside from just asking an AI to develop a solution to your problem. So why does this matter? I have had a discussion about this with many clients and spoken to groups about this issue, and they all say to me, well, we're not going to tell anyone that the AI has invented our invention, so what does it matter? No one will really know whether it was me or inventor. And the answer to that is that someday when you want to enforce your patent, when your patent has been called into question by someone trying to invalidate it, you may need to defend the validity of the patent. And I'm sure, and you can quote me on this 5 or 10 years from now, that the question of who was an inventor and whether patents were invented by an AI or by a human being is going to be a very common, if not standard, way of attacking inventions going forward. I think we all know that AI is going to continue to become more and more important in business and in product development and in research. And so what do? It's best to be prepared for that inevitability. You don't have to change the way you're inventing things. You don't have to stop using AI. Of course, none of us will. But I think what will be important is preserving some evidence of what your contribution was. When I first started this patent practice about 25 or so years ago, the US actually was not, its laws weren't quite harmonious with the rest of the world. And in the US, it was the first person to invent something that could receive a patent. Now, about maybe 12 years ago, almost 12 years ago, we changed our laws, and we line up with the rest of the world in saying that the first person to file a patent application for an invention that they invented gets patent. But the reason I bring this up is that what we would advise at the beginning of my career, for the first 12 or 13 years of my career, one of the most important things we told inventors and companies who were making things that they might want to patent is keep a record. We told an engineer, keep a journal, an invention notebook, and write down what you did, when you did it, contemporaneously to inventing, date it, sign it, whatever it takes, so that someday you can have good evidence that you invented it first. Well, now I would say the same thing is probably a good practice as it was 25 or 30 years ago in the US. Just make some notes, keep track of what you're doing, and someday when someone accuses you of having filed an application for an invention that was created by Davis or whoever your favorite AI is when that happens, you will have an answer. And I'll turn it over to Andrew, unless there are any questions.
So if you're going to use AI in any sense, it's important to know what's actually going on behind the scenes and what's happening with the data that you provide to the AI system, and perhaps what you're getting out of that system. And many AI will continually learn from user information. So that means that they're initially trained to do something, and then as they receive more user inputs, they're using those inputs and the outputs and feedback to retrain and get smarter. But what that means is that information that you provide as an input may later be provided as an output in some form. And Vanessa perhaps suggested this, perhaps the Nexora output was actually an input that system, that ChatGPT had once received from somebody else. So in the case of public AI, this is important because it means that information can be shared between different people, different users, and potentially users on different sides of the world that are in very different positions. Why does this matter? Well, it's under patent law, public disclosure can preclude patentability. And that's true across the globe. So if you provide information to an AI system, if it accidentally outputs that information in some way, that could constitute a public disclosure that keeps you from ultimately getting a patent. And a real world example of this might be if you ask an AI system to help you solve some technical problems you're having while developing your invention, performing some routine calculations, say to analyze static forces on a structure, and you give the AI system information about that structure, perhaps images of that structure or a free body diagram representing that structure, that AI system may ultimately use that information if somebody else asks about potential solutions or potential structures that may be similar, or may use portions of that image in generating images that somebody else asks for. And that disclosure could preclude patentability of your invention. It also means information you receive may be subject to unknown licenses or agreements. In Vanessa's case, the information you receive back maybe somebody else's trademark. Where this also happens is using code snippets. A lot of time, software engineers will provide code to AI and ask it to debug the software, or ask it for code that can perform a certain function. But a lot of times code is governed by various licenses, the MIT license or the GNU public license, that ultimately requires products, or alleged to require products that use those code to be open source. And ultimately, you may not want your software to be open source. So what you need to do about it is one, if you're going to use the AI system, be sure to keep your prompts as generic as possible to limit the amount of disclosure that you provide. And also keep in mind, be careful what the outputs you're getting back from that are actually telling you. And also consider using closed AI systems if at all possible. There are lots of companies out there now developing AI systems that you can create locally within an intranet, within a business, that aren't getting other data from the outside and aren't providing your information to anyone from the outside. So it's being retained within the business or the entity that the information needs to stay confidential with. Just to kind of quickly give an example of what this looks like in the real world, and this isn't meant to be a full discussion about ChatGPT or OpenAI, and certainly they have many other terms of service that try to limit liability and limit what you can do, but it's important to see what they're actually telling you. In the first instance, the ownership of content, it says, as between you and OpenAI, in the extent permitted by law, you retain rights in the input and own the output. which sounds great, but it's important to keep in mind that that's only between you and OpenAI. It doesn't say anything about the original ownerships of that work, or the original authors or owners of that work. They also mentioned clearly that they collect your personal data and that you provide to the input, such as prompts, images, and audio, anything else you provide, and then use that content to provide, maintain, develop, and improve the services, meaning they use that content to further train the systems and make them better. And that's fully within their rights. And lastly, they expressly acknowledge that outputs generated by their code generation features may be subject to those open source and third-party licenses. So they're telling you what they're doing. It's important to keep in mind exactly what rights you have in the data that you provide, what you're allowed to do with the data coming out of the system, and the implications that might have on what you're doing. So the last thing we wanted to touch on is what happens if the AI is the invention? As Aaron mentioned, AI can't be an inventor, but perhaps there are things that can be inventive that are based on AI. I tend to think that AI use cases fall within three main buckets. One is just performing data processing tasks. So AI can do a lot of really rigorous data analysis. It can do it very quickly, and it can do it very accurately. But in a general sense, most patent offices, and particularly the USPTO, view that as nothing more than a generic computer. As advanced as AI may be, they see that as AI doing something it is known to do in a known way, in a way that yields predictable results, and often consider using AI for that purpose to be obvious. So if you're only using AI to perform basic data processing techniques, it's generally difficult to patent. But sometimes AI can enable new processes or new techniques. One example I was thinking of is, and I don't know a whole lot about video editing, but perhaps traditionally, if you were filming a live scene and a car drove through the background, maybe in the past it was possible to remove that car from the background, but you had to do it in post-processing. You had to have the entire video and frame sequence to be able to do that, and you had to know what you were looking for and know that there was a car there that you were trying to remove. Perhaps AI can enable us to do that in real time without knowing what's going to happen, and can do it frame by frame without having to see the entire frame sequence. So in that case, AI would serve to, it's still performing data processing and still doing it in somewhat of a known way, but the use of the AI has enabled us to process videos in a very different manner and generate real-time image manipulated videos that we could not do before without AI. In those cases, it's likely possible to protect how the AI is used in that larger process. And the last bucket are things that relate to the AI itself. So if you think of the structure, the various layers and the architecture of the AI, or the methods used to train an AI system, those are also things that are generally patentable. But it's important to consider enforceability of those inventions. So AI by its nature is sort of a black box. You don't know necessarily what's going on. You know what the input is and you know what the output is, but you don't know what's going on, how it's getting from point A to point B. And often software these days is provided as a service, so you don't even have access to the software. You just provide the information somewhere else, and it spits the output back to you. It's not a mechanical device that you can pick up in your hands and feel and play with and really analyze to determine whether that product is infringing. So because of that, AI can be difficult to evaluate infringement of AI-related patents. Some of those details you need may come out in discovery in the US, but getting to that point is a very expensive and difficult endeavor. And at the end of the day, you may not even find out that there's actually infringement. But it also means that inventions, AI inventions, can be difficult to reverse engineer. And that means that there are also alternative forms of protection that you can pursue other than patents. So one thing to consider perhaps is trade secrets for AI-related inventions, where you keep the technology secretive to yourself, and provide access to it in limited ways, or use it for however you need to use it, but you don't actually file a patent application. You don't explain to the world what you're doing. It's just important to keep in mind that, at least in the US, there are very specific and certain requirements to be entitled to trade secret protection. It's not bestowed upon you just by doing something. Another one to consider is copyrights of perhaps the training data, copyrights of the outputs that are provided by the system, depending on how you're utilizing it, and what the valuable information is. And there are perhaps many others if you think about the various implementations of AI and what you're trying to protect. But the idea is, sometimes we may default to patents, but AI requires a creative approach to protecting that IP. So with that, I thank you all for your time, and if there are any questions or comments for any of us, please let us know.
Hi, I have a question from Taylor for Aaron. They wanted to know if you have an example of an AI-assisted invention that successfully passed and or failed the PNU factors that you described.
I don't have an example, but I can say that there are certainly many. And in fact, maybe it's even more important to consider the fact that we won't know probably for years what the result of all of this will be, because it's very unlikely to come up during the process of getting a patent. As I kind of briefly touched on, the Patent Office does not ask you to reveal this information that you used AI to help develop. And so, we won't see decisions from the Patent Office in the near term about whether a patent should be granted based on its inclusion of AI. But I think over time, what we're going to see is challenges to granted patents. I could certainly come up with examples of things that I think are contributions that would be significant or not, but that would be guesswork. The real answer, I think, is going to take years to find out. But I think to kind of plug what I was saying in my last slide, I think the important thing is to go ahead and patent your invention, but keep a record in case you have to defend the patentability. And as we learn more and more and see more cases like this occur, we will find out what it's going to take to overcome those PNU factors, or whether the PNU factors will even be the real test in the courts in the future.
Right.
So hopefully that wasn't a direct answer to the question, but hopefully that helps.
And we have a question. Someone would like to know, is not the 2 USPTO publications in 2024 dictate an ethical responsibility on practitioners to include AI aspects?
Not sure I know which 2 USPTO.
I think maybe in one sense, there is an ethical duty to be honest with the Patent Office, and to the extent that you use AI and an AI under the PNU factors or any other analysis might be considered an invention, it would be unethical to lie to them about inventorship, and that's going back to human inventors. That's been an issue for a long time, and getting inventorship wrong ethically or unethically can be grounds for invalidating a patent.
Yeah, and to supplement what Andrew is saying, I see a follow-up to that question as the question is about an ownership and inventorship. And I wonder if the question really is now that the USPTO has put these guidelines out there, that creates a duty to disclose that information that didn't exist before, and therefore could result in violating ethical responsibilities if you don't. That's a hard question to answer, but I would say my instinct is that it doesn't automatically mean that you have to disclose more. It certainly means that you should consider those things, and that you should know what the law is or what the PTO guidance is before you name an inventor. If you knowingly name an inventor with the guidance that exists now that you know not to be a true inventor, that could be a violation. But I don't think the guidance itself creates a responsibility to disclose that information to the PTO or otherwise, until and unless such a requirement is added to the rules or the statute.
Does anyone have any other questions? You can ask those in either the Q&A or the chat. In the meantime, I'd like to thank all of our panelists for a really interesting and informative presentation. This has been really great. I'll come back on screen. Thank you so much. Oh, here we go. Given that correcting inventorship for humans is less severe, but there's no correction for non-human inventorship, does this create an unknown zone?
Perhaps. I think that I'm not sure in what context correction would come up, at least as of now, since an AI or a non-human can't be named as an inventor, the PTO will not accept it. Perhaps you wouldn't have named one that you have to remove, maybe, and failure to name an AI as an inventor wouldn't be an issue because you simply can't do it. But if the law changes, that could become an issue.
Okay, any final thoughts from our panelists?
Thank you very much for listening.
Right. Thank you so much.
Thank you.
And thank you, Lindsay and Vanessa and Marissa, for joining me today and for arranging this.
Thank you so
Thank
much
you
It was a
to
pleasure.
all of you. Thank you so much to our audience for fantastic questions. This was really great, and we appreciate all of you. If there's anything you'd like to review, I will be putting a recording of this up on our YouTube channel and sharing it with everybody who participated today. Thank you again, and we will be back with you again soon with more webinars. So please take care, everyone, and thank you again.
Thank you. Bye-bye.
Thank you.
Bye.
Good afternoon, good evening. Bye-bye.
Bye.